minutes above 4. If necessary.
I'm grateful, Lord. I will try my best, Lord. I would have left it, but for my inner strength.
No, definitely.
Because I'm giving a small addendum focusing on section 3 in which we were discussing yesterday. If I may read the first few paragraphs from this note. Section 21, 1 of the RP Act 1950 relates to the first preparation of the electoral roll on the basis of which the elections were held for the first time. After enforcement of the Constitution of India, Section 21(2) relates to revision of the said roll. It would apply to all revisions which take place after the first preparation of electoral roll. Section 21(2) deploys the expression unless otherwise directed. In Section 21(2)(a), it has no application to Section 21(2)(b). This expression indicates that the electoral roll would ordinarily be revised as per the prescribed rules, but the ECI has the discretion to issue directions for revision otherwise than as prescribed by the rules. The expression unless otherwise directed in Section 21(2)(a) is significant, and it relates to the manner of revision and not when the revision will take place. It is notable that Section 21 of the RP Act as enacted in 1950 did not contain any provision envisaging a discretion in the ECI to depart from the rules. Section 21(3) as it stands now was inserted by Amendment Act 1956. The 1956 Amendment Act did not introduce any discretion in 21(2)(a) in favor of the ECI. Until Amendment Act 1966, the expression unless otherwise directed was not mentioned in Section 21(2). In fact, Section 21(2) underwent change via Amendment Act 1966. For the first time by the Amendment Act 66, unless otherwise was inserted in 21(2) as it now stands. This indicates that Parliament intended to introduce a discretion in favor of ECI even under 21(2)(a) and supports the submission of the ECI that there is a discretion in favor of ECI both under Section 21(2) and 21(3) of the Act. Here you'll also note that the case of Inderjeet Singh Barua, which I cited, your lordships have in a constitution bench upheld the direction of the ECI that there will be no revision and election will be held as per 1979, and it was upheld under the main part of 21(2)(a). So there is some discretion there also, but keeping in mind the rules, etc., which is there, you may deviate some. A notable feature is that whereas under Section 21(2)(a), the ECI is empowered to deviate from the prescribed rules, 21(3) vests a discretion unconnected with the prescribed rules, and the discretion is vested notwithstanding 21(2). Section 21(3) deploys the expression in such manner as it thinks fit. The manner, therefore, is left to the discretion of the ECI. This is very important, Lord, because if we bring in 25(2), 25(2) touches upon the manner. It says do it as per 21(1), applying rule 4 to 30. The expression as it may think fit has been interpreted to have a wide ambit. Reliance is placed on the following cases. I'm not reading words. Ordinarily, any is held to be wide unless there is something in the context which compels.
This is as it may think fit, which is like not.
Oh, I'm sorry. As it may think fit, therefore, is a wide power. It thus submitted that ECI is well within its domain to devise a mechanism unrestrained by the prescribed rules under RER 1960 and to conduct the SIR as per the order dated 24/6/25. Petitioner's reliance on Rule 25 is misplaced. Rule 25(1) in terms applies to Section 21(2). It empowers the ECI to choose either to have an intensive or summary or partly intensive or partly summary revision. Rule 25(2) introduces a limitation to the effect that if the ECI directs intensive revision, the electoral roll or part thereof shall be prepared afresh. And Rule 42223 shall apply as it applied to the first preparation of the electoral roll, that is, under Section 21(1). It is submitted that Rule 25(2) is intricately linked with Rule 21(1), and both apply only with respect to Section 21(2). In fact,
It is not Rule 21, but it could be section.
oh, that's a typing error.
Last line, right side.
That's section words. Kindly correct me. Apologies. In fact, the whole of Rule 25 is correlatable to only 21(2). It has no relation to Section 21(3). The contention that Rule 25(2) would apply also to Section 21(3) of the RP Act, where the role is being revised intensively, is erroneous. It is submitted that this contention overlooks that Rule 25(2) cannot curtail the ambit of the discretion vested in ECI under Section 21(3). The object of Section 21(3) is to override 21(2) by deployment of non-obstante clause and to enable the ECI to direct a special revision of the electoral roll in such manner as it may think fit. What the ECI chooses is not simply the intensity of revision, the manner, but also, again, that's missing, kindly insert note, but also the manner of revision. The expression in such manner as it thinks fit. The petitioner's contention to apply Rule 25(2) to Section 21(3) would make Rule 25(2) ultra vires for being in conflict with Section 21(3). By virtue of Section 21(3), the manner of revision is to be fixed by ECI in the exercise of power under Article 324 of the Constitution of India and not under Section 28 of the RP Act, that is the rule-making power. The aforesaid must also be read in light of variance in text of subsection 2 of Section 21, which uses the phrase revised in the prescribed manner, as against subsection 3, which uses the phrase in such manner as it thinks fit. If the argument of petitioner is accepted and subsection 3 is also read as subject to prescribed framework under RER 1960, the express clause 3 becomes redundant and odious. It is well settled principle of interpretation, which would make terms used in statute odious has to be avoided. It is submitted that once an SIR has been directed by the ECI under Section 21(3), the ECI becomes authorized to provide the manner in which SIR will be conducted, as is evident from the expression as it may think fit. The COI, the Constitution of India, the RP Act, RER Act 1960 vests sufficient authority in ECI to undertake and direct an SIR. The impugned SIR order dated 24/6/25 is therefore legal, valid, and within the competence of the ECI. It does not run counter to the provisions of the RP Act or the RE Act. The petitioner's effort to bring out Rule 25(2) into play with respect to an SIR under Section 21(3) because of the revision being intensive and in consequence brings Section 21(1) as well as Rule 423 into application is a convoluted submission which introduces absurdity and results in destruction of ECI's discretion under Section 21(3).
So we look at उसमें नहीं but उनके पास written submission है। इसमें नहीं है तो
कहाँ लगी? I'm sorry, Lord, this my copy is. Yes, I'm sorry, Lord. The part
The impugned order.
kindly have from the 5th line, the impugned SIR order dated 24/6/25 is therefore legal, valid, and within the competence of the ECI. It does not run counter to the provisions of the RP Act or the RER 1960. It is submitted that the expression special revision and in such manner as it may think fit clearly indicate that the ECI's authority to prepare electoral roll under 324 of the Constitution is preserved. so as to enable the ECI to deviate from the rules prescribed under Section 28 of the RP Act, that is RER 1960. The Parliament has not shut out the constitutional discretion of ECI completely. The Parliament has only imposed the restriction of recording the reasons for directing special revision. The reasons are only to explain the need for deviating from the prescribed rules to achieve the objective of revision of electoral roll. Consequently, it is permissible for the ECI to provide for additional set of documents or set of documents different from those specified in Form 6. The forms can also be suitably altered. The ECI has given good reasons for having an SIR under 324 of the Constitution of India read with Section 21(3) of the RP Act. It is also emphasized that Citizenship Amendment Act 2003, and this is very important, my lords, because after the previous SIR 2003 Citizenship Act was amended, and the person has to establish the fact that both his parents were born in India also before, in order to become a citizen. So that's a vital change, and as the Lordship saw it, it was to make it more stringent. The citizenship, which was earlier easier, was made stringent because of the inflow of illegal cross-border migration. So this also happened. It is emphasized that Citizenship Amendment Act had made significant changes in Citizenship Act 1955 with respect to conditions for being accepted as a citizen of India. The summary revisions which took place during the last 22 years were based on self-declarations and had not scrutinized citizenship in the light of 2003 Amendment Acts. The petitioner's effort to bring Rule 25(2) into play with respect to SIR under Section 21(3) because of the revision being intensive, and in consequence bring Section 21(1) as well as Rule 4 to 23 into application is a convoluted submission which introduces absurdity and results in destruction of the ECI's discretion under 21(3). The petitioners also, Mr. Sibbal's argument was to refer to Section 28, subsection 2, which talks of rules being made for revision. Well, that's a normal provision which is made in every act for making of rules. However, Section 28, in particular, subsection 2G, H, HH, and HH, to assert that revision of electoral roll has to be done in accordance with rules. It is submitted that no rule has been made under 28 with respect to 21(3), nor can the rule-making power under 28 be used to curtail the discretion of ECI under Section 21(3). This discretion had to be exercised by ECI under Article 324 of the Constitution read with Section 21(3) of the RP Act. SIR is a special revision conducted under Section 21(3). It is not restricted by rules prescribed under Section 28, along with Article 324, Section 13A, 15 provisions of Section 21(3 enable ECI to conduct a special revision with such intensity as it deems essential to ensure purity of electoral rolls in nationwide exercise. So this, Lord, is my humble submission, Lord, with regard to the interrelation 21.2, 21.3 and Rule 25. Now, the other argument was, Lord, that any constituency. Mr. Singhvi presented before a Lordship 5 clues to hold that any constituency in Section 21(3) means either one or a clutch of constituency, but it cannot extend to cover all. Now, this, Lord, on the basis of it, the very submission negates the idea which my learned friend wanted to, because once you extend from one to a clutch, now whose clutch and how big is the clutch, it will depend upon that, Lord. So ECI's clutch, Lord, is the whole constituency under Article 325. A roll is to be prepared for a constituency. So the clutch can't be, then it creates more problem. Should the clutch include only 1 + 1, 2, 3, 10, 5, where, or supposing, Lord, if there are 254 constituencies in the state, we say for 200 and leave out 45. creates a whole lot of problem. But however, look at the clues which were presented. I have set out those clues. Structure first was structure of section 21(3), that is the expression any constituency or part of constituency. So the expression which is to be interpreted is used to be by itself to be a clue for restricting. Second was the word many in, I'm sorry, kindly delete M. The word any in the context cannot mean all. The real question was, what is that context? What is the peculiarity in the context which compels to restrict it to one or a little more or some more? 3, the requirement to record reasons. I have already submitted that reasons are only for the purposes of why we are deviating and nothing else. There is no list involved, no adjudication between parties, no parties' interest as such, either political parties or otherwise involved. The proviso uses the expression for the constituency, which indicates some individual constituency or a clutch of constituency. The existence of non-obstante clause rules out coverage of all the constituencies. It was said that never before in the past an SIR was conducted in all the states. So what has never been done in the past, Lord, because of that, Lord, if it is to be prohibited, it is submitted that the deployment of a non-obstante clause and the word any before constituency would clearly indicate that all the constituencies of the state would be embraced in an SIR. While it is correct that any has to be construed in the context, but nothing particular has been shown in the context to restrict the meaning to a single or a clutch of constituencies. Once the petitioner concedes that a clutch of constituencies would be covered by ambit of 21(3), it would follow that 21(3) contemplates a plurality of constituencies. Logically, all the constituencies of a particular state will fall within the ambit of section 21(3). Moreover, section 23 has to be given a purposive construction. It is known that in the past also special revisions have been undertaken under 21(3) on more than one occasion. It's not necessary that each SIR should be identical or equally expansive. If an SIR has not been conducted in all the constituencies for the last over 20 years, if there has been migrations due to rapid growth of urbanization, if there has been large-scale illegal cross-border migrations, if there has been intrastate migrations due to marriages, if large number of duplications exist, both intrastate and interstate, the problem needing special revision clearly exists in all the constituencies of the state and in all states. In this backdrop, there is no reason to curtail the ambit of section 21(3) and limit the discretion of ECI to one or a clutch of constituencies. Some cases have been mentioned, Lord, I will not read. I have given the paragraph where any has been construed in a wide manner too, as all. Especially in Article 304A of the Constitution, Free Trade and Commerce. Any tax was held to cover all the taxes which the states can impose. In MS Gill's case, this is significant, my lord. In MS Gill's case, I've already cited, this Honorable Court considered cancellation of the polling in all polling stations of a constituency in Firozpur, Punjab. This court considered Section 58 and 64A of the RP Act 1951, which uses the expression at a polling station and at that polling station. In the light of the contention that Section 58 and 64A do not empower cancellation of the polls in all polling stations, this court observed it is not the case of either side that the total repoll of an entire constituency is not specificated in the sections of the rules. That being so, this court examined Article 324 and held that cancellation of all polling stations would be available under Section 324. Justice Goswami has observed, although Section 58-64A mention a polling station or a place fixed for the poll, it may, where necessary, embrace multiple polling stations. If so, there is no justification for reading the expression any constituency in Section 21(3) as excluding the coverage of all constituencies in a state. Some of the petitioners contended that SIR does not record reasons, although Section 21(3) mandates that reasons should be recorded for directing a special revision of the electoral roll. It is submitted that paragraph 7 of the SIR order, dated 24th June 25, sets out the reasons for undertaking special revision of electoral rolls. The first is there has been rapid urbanization. Second, there has been frequent migration of population due to education, livelihood, and other reasons. And that has become a trend. Thirdly, there is also a large-scale duplication of entries on existing electoral rolls, leading to increased possible of repeat entries. Fourthly, Article 326 requires that only Indian citizens should be registered on the electoral rolls. Therefore, an intensive verification drive to verify each person before enrollment is necessary. This is also important, Manoj, that the object was to verify. The fifth circumstance is the amendment of Citizenship Act 1955 in the year 1986 and 2003, which required determination of citizenship on the basis of not only the person concerned. Sixthly, moreover, political parties across the spectrum have voiced serious concerns regarding the accuracy of electoral rolls revised through summary revision process. In fact, not everybody in the country is reading with all political parties saying that in Haryana this is wrong, in Karnataka that is completely, in Maharashtra this has been added. So, if in this backdrop, now the same very political parties say don't do SIR. That is a contradiction in their approach. During the course of argument, most of the petitioners conceded that conduct of SIR is necessary. In particular, Mr. also recollect that Mr. Yadav said that he feels that SIR is absolutely essential, but he has problem with the designs only. Since the SIR order is legislative in character, therefore the reason set out in brief in the SIR order is sufficient to indicate the necessity of undertaking special intensive revision. I quoted as some paragraph note 85 from KT Plantation. In our case, since the law requires recording of reasons, therefore we have to give reasons. But reasons are not in the context of adjudicatory reasons. It is submitted that Section 21(3) does not require reasons to be stated in a manner in which reasons are recorded in adjudication or quasi-judicial determination. It only requires reasons to be recorded to justify the undertaking of special revisions. It is submitted that reasons indicated and in para 1921 of counter affidavit are sufficient to establish. Now they may argue that you can't supplement from the counter affidavit. That's a principle where some lease is decided or some order is passed against a person which impacts him, which has civil consequences, then the court says that you have to confine. When an order is passed of an SIR which is legislative in character, then one can always present the circumstances in greater detail, etc., in the counter affidavit. Those cases of not supplementing are only in the zone of quasi-judicial order or administrative order having civil consequences. Like in Menka Gandhi's case, where passport issue was involved, there the court says, therefore, that you can't supplement. Or if a polling station is cancelled, as in the case of Mohinder Singh Gill, then that's an administrative order directed at a particular polling station for particular reasons, applying the rules. Now, Section 62, I have already made my submission. Your Lordship may note that Section 62 I have dealt with. I have already made my submissions yesterday on that. If your lordship has page 168 of the written submission I was reading yesterday. Part two.
Part two.
Yes. At page 168 is the SOR of the Citizenship Amendment Act 2003.
Yes. Yeah.
Now this comes into operation not after the SIR of 2003 had been completed. This is a vital change. And the other important aspect is that this Amendment Act of 2003 was introduced in the Parliament and passed when Shri Atal Bihari Vajpayee was the Prime Minister. But there was complete consensus that this was required on both sides. No opposition. And it was, Section 1 said that it will be enforced on such date as notified. And the notification came to be passed when Shri Manmohan Singh was the Prime Minister in 2004. That itself indicates that across the political spectrum, this amendment was considered to be desirable. Please just see the first page.
Mr. Dwivedi, there is no contemporaneity between the enforcement of the amendment and the notification for special revision in 2025.
Sorry?
It's after 2 decades.
No, that's what the problem is. That over the last 20 years in that it was all summary based on self-declaration. So the application of this
is not there in the special revision. No.
That's precisely what I submitted below. If I'm right in my submission that this order is of a legislative character,
You can supply additional.
then I can give additional reasons. And in any case, it's a statute, my lords, of Parliament. I have said that under 326, citizenship has to be examined. One may say, my lord, one could have also more expressly mentioned this. But the idea to examine citizenship is there in express terms.
Is that a reason or just prefatory statement?
No, that's
The
a,
reasons appear to be three.
no, because
One is urbanization, third is migration, and second is migration, and third is wrong. And
that's paragraph 7.
that is
But if I am right that 326 requires citizenship to be examined, and if the law has been amended by Parliament in 2003, subsequent to
that's the
the
question we are posing to you. Was the requirement of examination of citizenship in light of the amendments to the Citizenship Act a trigger? Because that trigger does not find eloquent expression in the SIR. You are right that you cannot.
maybe, my lord, it could have been expressed more clearly, more happily. But what I'm trying,
You are talking more of migration between one state to another, wrong entries, etc.
and even cross-border migrations.
Cross state, that also we.
The word migration, my lord, will subsume, my lord, as the lordships are also pleased to observe, my lord, during the debate. Interstate cross-border
and
migration.
Inter-country migration are quite different.
No, it's different. But like word migration.
Your SIR does not pinpoint that it is trans-border migration
So, my lords, we could have said
or illegal migration.
we could have said, my lord, that migration, instead of that, we could have said intrastate migration, interstate migration, cross-border migrations,
There is a difference
or
between
use one expression, migration.
state and country.
My lord, if word migration subsumes interstate, intrastate,
Mr. Dwivedi, migration, when it is interstate, it is always lawful migration. So word migration means lawful migration. When you talk of inter-country migration, it may amount to illegal migration. Because in India, everyone is entitled to, if he is a citizen, to move throughout the country because of fundamental freedoms. It can only be illegal if it was between a country and another country. And when you use the word migration simpliciter, then we will interpret it's an inter-country migration.
My,
How can it be an
my submission is twofold.
interstate migration?
So my submission is twofold. First, that even if we exclude this 2003 Act, 2003 Act,
Sir, we have followed your submission that there is constitutional power traceable to Article 324, and one of the qualifications for being in the electoral roll is citizenship. So you argue that there is a constitutional duty, forget about power, a constitutional duty to examine citizenship of any individual. Our question to you is,
about the reasons.
when you are starting a special revision, was that in your mind? What was in your mind says migration, says urbanization, etc., etc. It does not clearly say illegal immigration.
Obviously, it doesn't say that, no?
That is what we are saying.
Now-
Is it now second guessing the special revision?
So let me reframe my submission like this, Lawrence. One, even if we ignore this,
Hmm.
still the reasons which we have given,
Exactly, absolutely.
Are sufficient.
Well taken, well taken.
that's one. Second, I'm submitting that in as much as,
Why we are asking this question, Mr. Trivedi, maybe for us simplifying the problem for you. If you were to defend
yes,
a SR, not SIR, SR, for interstate migration or death or etc., then the bigger question of constitutional right and duty of determining citizenship does not really come into the fore. You are to defend a situation where 20 years have lapsed. There has been enormous movement of population throughout the country. Urbanization has taken place. It is everybody's case, as you rightly said, that there are wrong entries. So you go ahead with these are the reasons which require a special
That's right.
revision or special intensive revision. And you invoke your powers, which are much more, I would say, easier for you to have elbow space, that is subsection 3, to prescribe certain criteria
like-
for verification.
I would like to.
Now, is this your case? Why we want to know exactly what is your case? Are you defending an SR to go into the question of illegal migrants?
No, no.
Because that is
No.
not very eloquently stated in your.
No, I'm even now when I'm placing this Citizenship Amendment Act, I'm not going to illegal migration. This act is not about illegal migration. This amendment is about citizenship.
Correct.
So I'm not saying that, Lord, I have not, pardon me if I have used that expression indicating that illegal migrations. No, we are
No,
not examining that.
No, but you have not said so far.
Yes. What I am submitting is that this Citizenship Amendment Act has changed the norms of citizenship, which has come after that, in as much as we are compelled to examine in a revision.
You are relying upon para 2 of this.
Then, my lords, the changed norms which have never been applied in a summary revision during the last 20 years also becomes a factor. And this being legislative, this aspect can be seen, it's a statutory document.
Yes.
That's all I'm trying to add. I'm not saying, I'm saying the reasons in paragraph 7 by themselves are sufficient to justify undertaking of the SIR under 21(3). 1. Second,
21(3).
to that, I'm adding on my own that this exercise being legislative in character and this Amendment Act having come after the previous SIR and have never been applied in between because it went on self-declaration of citizenship coupled with filing of objections under Form 7. Therefore, it was also right time, opportune time, since SIR is being done, to take note of this and examine. And that's the reason why we have extended. Now, why I'm citing this is that when SIR says that those who are born subsequently have or become major subsequent to 2003, if they are linked with the 2003 list, means their parents are there. That fulfills the amendment. Again, all this could have been spelled out more clearly. But the idea of not asking those who are linked, able to succeed in established linkage, not to file documents, that is on account of, because Amendment Act now says you prove your own and your parents. So therefore, this also enables, Lord, when I directly, again, very briefly, I'll touch upon the SIR, how it is fair, just and reasonable. The rationale of this linkage, which has been argued, why not 2003, why SIR? So, probative value to 2003, linkage enables most of the people, 76% electorate did not have to file any document in Bihar. Only 20, it reduced to 24%, and everybody was able to file the 11 documents. Hardly anybody who not, and those who are rejected have not.
You definitely have a case because hardly any appeal was filed.
No appeal filed, no writ petitions filed.
Right.
Nobody has come before your lordships.
No, it's about to bring.
Six and eight clearly contribute that's not the fundamental conditions of 326 is referred to Indian citizens.
वो तो ठीक है.
एक जो है ये रिक्वायरमेंट जो 326 की जो 3 रिक्वायरमेंट है they are continuing for every election and that is why I say as a vote at any such election in every such election.
So lordships, sorry. Now, I was referring to this SIR only to show that why did the parliament make this amendment? Because of the illegal migrants coming in. Therefore, it made this stringent. And that's what the SIR
That's
said.
what you see in the 2003 amendment.
Yes.
You see, it is very interesting. It says both parent citizen, then see clause B, one parent
One
citizen,
parent, other
and
should not
one
be
is not
illegal.
an illegal migrant.
Should
So
not be illegal.
it is not necessary that both parents require to be citizen. If one is a citizen and one is a lawful migrant, then also your citizenship is there.
Also.
It's
Like
not that
OCI,
I have to show, if I am born after 2003, that both my parents are Indians. I have to show that one of my parents is an Indian and another is not an illegal migrant.
so it has been extended to cases of OCI or recognized refugee or something like that.
Yes.
Those who are staying with permit under visa,
Even visa.
long-term visa.
Long-term visa.
Yes.
A foreign national entering India with a visa, giving birth, entitled to a citizenship.
So this was a very vital change.
Very right. That's true. That's true. That is why we asked you, this is not articulated in it only has one line that you have a right of citizenship, citizen. As you said, paragraph 7 is more on internal
right.
movement.
Yeah, what is written, Lord. We can't.
So we examine whatever is written as it.
But therefore, I say, my Lord, that then look at the nature.
So that's why he say, are you second guessing the
No. We are not. I'm not second guessing, but I'm trying to place a
Because what
statutory
we are
thing.
seeing is what was in the mind of the commission when it passed the order.
So I'm putting it like this, that what was in the mind of the commission was that it's time to examine citizenship under
Well
326.
taken. That is well taken. 2 decades have lost.
Yes.
Changes.
And it's a well-known fact, not this case of from Assam has come twice, so and all that.
Hal ho gaya. क्यों नहीं कर?
And practical experience shows us, all we are aware, that people from East Bengal and from Burma also, reasons may be whatever, justifiable from human angle or not.
You would have permitted this to be argued, Mr. Dwivedi, if you had said this as recitals in the SR.
So I'm not
No
arguing.
recitals in the SR that
I'm not.
X amount of migration.
No, I'm not
illegal
going into that.
migration
No,
through
no.
the eastern borders, through the northern borders. It's
I'm not going. I'm making it clear. I'm not doing that. I'm making a very limited.
Suicide करने के बाद the court has now decided to begin SIR in for discharge of its constitutional mandate.
So I say there is no express mention. In that context, I submit twofold again, if I may respectfully
We have
read.
followed the submission, sir.
That one, the reasons spelled out are by themselves sufficient. And to that, I am trying to say that looking at the nature of the SIR, it would be permissible not to explain what were the other. And this is very clear, my lords, on the face of it. Where is that? One argument, my lord, was submitted that this is never before such an SIR has happened. And a facet was that in 2003, it was different, especially Mr. Bhushan Malad stressed on this aspect, that it is different from the 2003. So my humble submission, my lord, is I have dealt with this at page 21 of my written submission. But if I may just spell it out straight away, my lord, that there is no compulsion on 21.3 that all SIR should be of an identical format. It depends upon, supposing, my lord, an SIR is being done in 89, 90, 90. If I lordship turns to paragraph 21, see, this is also there in the SIR. In the last line, I have indicated when the SIRs were done. Now, if it is done in 87,
21.3 argument is accepted. Your 21.3 argument is accepted. Then issue and then when do you want, why do you want, accept that reason must be
how
assigned.
much should be the intensity, etc., my lord, has to be left to the election commission, as
And in
long
any
as the
case-
boundaries of fair, just, and reasonable is not being contravened.
Even it makes sense not to replicate or repeat what done in 2003. With the passage of time, 22 years more, lot of technology, lot of migration, population, urbanization, rural, all this. So there can be always new factors.
Yes. But what I am indicating is that supposing an SIR has been done in 87, 89 already, and we are doing in 92, if it has been done in 92 and we are again doing in 1993, so the intensity will be less. We have already done it 1 year back. But if it is not done for 20 years, and now we are doing, so it has to be, my lord, per necessity, something different. Nevertheless, I have explained, my lord, that even in 2003, enumeration forms were there, and this house-to-house survey was there. Yet another facet was, my lord, that the manual has not been somewhere here or there. If the rule, we can deviate from the rule under 21.3, surely, my lord, the administrative directions which are contained in the manual, they will not, my lord, restrict the exercise of power under 21.3.
Sir,
It presents a compendium of what was being done during a summary exercise. Compendium does not deal with an SIR. The SIR manual has nothing to do with SIRs. It doesn't detail or does not hidebound, nor it can hidebound a determination of a design of SIR in future. Next one, sir. Now, one argument, my lord, regarding men. दो ही जजमेंट का वो कहा हमने नोट किया सर
कहा 2-3 सबसे भी फोन कर
हर एक पे का 4 हो जाएंगे
हाँ तो क्या
हर एक So I'm moving on to Mr. Singhvi's vehement argument about manifest arbitrariness being substantive due process. Whole due process, he says, now has been injected into the Constitution of India. That was his submission, my lord. I have no issues with the Maneka Gandhi principle, my lord, which says just, fair, and that has been followed. But the problem, I have serious problems with this due process, which Mr. Singhvi wants to import, my lord, from the United States. At a time, my lord, when the United States is hardly following due process. Now, my lord, President Trump can just go and lift the president of Venezuela and bring him to US for trial. So where is the due process? US, that whatever is now, he wants Greenland. Where is, so the US Supreme Court is not applying due process to all this. But my learned friends are more keen, my lord, to go that way and to import it. But there was actually, they are not unjustified because Justice Nariman had, my lord, in Arif's case, that is 2014, volume 9 SCC, just 4 judgments, some paragraphs I will show my lord, quickly. The issue in this case was, my lord, whether the review petitions in death sentence matters should be placed for hearing in the court or should it be decided in chambers as other matters. That was the issue. Just have one paragraph of this, para 28. And 28 at page 756.
Justice Nariman and me, I think I was also there in the batch. We applied this principle of manifest arbitrariness in the subsequent judgment where we struck down some provisions of the Arbitration Act.
Yes, yes. So manifest arbitrariness, Your Lordship has explained in 6A, my lord, I will follow that line. That's the right.
But that principle is well known and well defined also.
Yes. The due process doesn't come in, but here some.
there is no question of due process, but manifest arbitration principle has been
Yes, I
followed.
accept that. I'm only questioning, please don't make it clear that due process as in American judgments is not applicable here. They used to strike down the rules not relating to number of hours the workers. They were limited to 10 hours. And the Supreme Court struck it down saying that this violates the right to contract. So the due process virtually allows the Supreme Court there, if they so deem fit, to strike down provisions based on rejudgment of the wisdom of the law, the policy decisions as such. Whereas your lordships have clearly said that we do not sit in judgment over the wisdom, whether this or that should be done. It's not an appeal.
Because due process has already been discussed in the Constitutional
That's
Assembly.
an uncharted ocean. If we bring in due process, then we don't know where it will end, and we have so many high courts followed. And now look at what has been said. I just read few paragraphs from 4 judgments. Close on the heels, that's para 28, close on the heels of Maneka Gandhi case came Mittu versus State of Punjab, in which case this court noted in Sunil Batra, while dealing with the question as to whether the person awaiting death sentence can be kept in solitary confinement, Justice Krishna Iyer said that though our constitution did not have a due process clause in the American Constitution, the same consequence ensued after the decisions in Bangladesh and Maneka Gandhi. There is no observation in Maneka Gandhi that due process has come in. Then they refer to Bachan Singh, and finally they say the wheel has turned full circle. Substantive due process is now to be applied to the fundamental rights to life and liberty. The last sentence. Substantive due process was brought in. The next is Shara Banu case where triple talaq was involved. I will give the paragraphs. And here this is a constitution bench where Honorable the Chief Justice, Justice Keher, as the bench was then, for speaking, they did not apply it. Chief Justice Korean Joseph did not apply it. So 3 judges did not. Only 2 judges have spoken. And that judgment.
Justice Joseph agreed.
Justice Joseph
Joseph
agreed
agreed
on
with
the
the majority.
reasoning. Justice Joseph agreed on the reasoning, but chose not to apply. So he expressly agreed with the reasoning on manifest arbitrariness of Justice Lalit and Justice Nariman's judgment. Expressly done.
You show it when your turn comes.
Sorry.
Kindly have a paragraph. Kindly note para 70, 74, 82, 84, 87 and 95. Your Lordship may have a look at Justice Korean Joseph, since my learned friend is.
I don't know.
शुरू है
Para 5.
Page was. His judgment begins at page 40.
Yes.
Let me read paragraph 5 first. In that view of the matter, I hold. Hello, just batches. I'm sorry.
No, no, you can read. You can-
Yes, actually, it's not recorded. In that view of the matter, I wholly agree with the learned Chief Justice. That is, I'm sorry, page 40. Page 40, paragraph 5.
57. Yes.
At page 440. Hello, just Bakshi has got.
Yes, yes, for you.
In that view of the matter, I wholly agree with the learned Chief Justice that the 1937 Act is not a legislation regulating talaq. Consequently, I respectfully disagree with the stand taken by Justice Nariman that the 37 Act is a legislation regulating triple talaq and hence the same can be tested on the anvil of Article 14. However, on the pure question of law that a legislation, be it plenary or subordinate, can be challenged on the ground of arbitrariness, I agree with the illuminating exposition of law made by. So he is agreeing with the testing of it on the anvil of arbitrariness. He is. Anything else you want me to read?
Once again, if you could.
I agree with the illuminating exposition. I am also of the strong view that constitutional democracy of India cannot conceive a legislation which is arbitrary. So manifest arbitrariness, I am not contesting. Where is in this note that he agrees that you bring in the due process note from America?
Manifest arbitrariness is another expression of substantive due process.
Yes.
Manifest arbitrariness is another expression of substantive due process. Where this problem arose from the judgment in 1990, where the question of substantive due process was not applied to primary legislation, but to delegated legislation or administrative action. In Shahramanu, Joseph Sain, and the series of judgments from 2010 onwards, Supreme Court elevated the judicial review test of manifest arbitrariness not only to delegated legislation, administrative action, but also to primary legislation. That's all. And that is where Justice Joseph agrees with Justice Nariman's view.
That's right.
That no law, be it primary law or delegated law, can suffer the vice of arbitrariness.
No problem so far. But the next step that it is equated to the due process, but the next step that it is equated to the you are bringing in now US due process, that's not there.
This expression has been on some occasion loosely used by the courts without having any special consideration that they are borrowing the American jurisprudence only. It's very clear about it.
But now kindly have 9 judges judgment of Pottaswamy, where the majority judgment of Justice Chandrachud deals with this and rejects this due process entry into India.
Exactly.
It's very important because this keeps coming up a lot. Some councils still feel a lot that we have to necessarily bring due process.
That is only a restatement of the correct law that has been consistently followed in this country. Right from Constituent Assembly debates to.
Yes, my laws are right. It was introduced in the draft constitution but rejected. Page 485, 2017 10 SCC, page 1. At page 485, Page 485, para 273, Lordship has.
Detail में देख रहे हैं. Justice Babu is saying this arbitrary is same as substantive. Have you seen the new syllabus in would you mind if we have in first year? We have introduced about how to create levels practice. No. Just myself.
May I please? During the course of hearing, Learned Counsel appearing on behalf of State of Gujarat submitted that requirement of a valid law with reference to Article 21 is not conditioned by the notion of substantive due process. Substantive due process, it was urged, is a concept which has been evolved in relation to the US Constitution but is inapposite in relation to the Indian Constitution. A history surrounding the drafting of Article 21 indicates a conscious decision by the Constituent Assembly not to introduce the expression due process of law, which is incorporated in the 5th and 14th Amendments to the US Constitution. The draft Constitution, which was prepared by the drafting committee chaired by Dr. B.R. Ambedkar, contained a due process clause to the effect that nor any state shall deprive any person of life, liberty, and property without due process of law. The clause as originally drafted was subjected to 3 important changes in the Assembly. Firstly, the reference to property was deleted from the above clause of the draft Constitution. Members of Constituent Assembly perceived that retaining the right to property as part of due process would pose serious impediment to legislative reform, particularly with the redistribution of property. The second important change arose from a meeting which Shri B.N. Rao had with Justice Felix Frankfurter in the United States. In the United States, particularly in the years around the Great Depression, American courts had utilized the due process clause to invalidate social welfare legislation. In the Lochner case era, the US Supreme Court invalidated legislation such as statutes prohibiting employers from making their employees work for more than 10 hours a day or 60 hours a week on the supposition that this infringed the liberty of contract. Between 1899 and 1937, 159, excluding the civil rights cases, 159, the US Supreme Court decisions held state statutes unconstitutional under the Due Process and Equal Protection Clause. Moreover, 25 other statutes were struck down under the Due Process Clause together with other provisions of American Constitution. Under the Due Process Clause, the US Supreme Court struck down labor legislation prohibiting employers from discriminating on grounds of union activity, regulation of wages, regulation of prices for commodities and services, legislation denying entry into business. These decisions were eventually distinguished or overruled in 1937 and thereafter. The Constituent Assembly in this background made a second important change in the original draft by qualifying the expression liberty with the word personal.
Mr. Dwivedi, you can start from para 290, in fact, because you are right, there is a detailed reference to the Constitutional Assembly debates.
The whole history is traced.
Yes, then thereafter, the view taken in different judgments, and how in some of the occasions the judges also misconstrued it. That has been referred to, and from 290 then.
290. Hello.
290.
The constitutional history surrounding the drafting of Article 21 contains an abundant reflection of a deliberate and studied decision of the Constituent Assembly to delete the expression due process of law from the draft constitution when the constitution was adopted. In the Constituent Assembly, the drafting committee chaired by Dr. B.R. Ambedkar had included the phrase, but it came to be deleted after a careful evaluation of the vagaries of the decision-making process in the United States involving interpretation of the Due Process Clause. Significantly, the present to the mind of the framers of our Constitution was the invalidation of social welfare legislation in the US on the anvil of Due Process Clause on the ground that it violated the liberty of contract of men, women, and children to offer themselves for work in a free market for labor. This model evidently did not appeal to those who opposed the incorporation of a similar phrase into the Indian Constitution. Yet the debates in the Constitution Assembly indicate that there was a substantial body of opposition to the deletion of Due Process Clause, which eventually led Dr. Ambedkar to objectively sum up the rival viewpoints for decision of the House. Evidently, due process was substituted with the expression procedure established by law. Liberty was qualified by personal. Having noticed this, the evolution, then I can leave 291 also.
296 then concludes.
Yes. In fact, Lords, 292 may be allowed. This is something which your Lordships also not have held in this section 6A. In dealing with a substantive challenge to a law on the ground that it violates a fundamental right, there are settled principles of constitutional interpretations which hold the field. The first is the presumption of constitutionality, which is based on the foundational principle that the legislature, which was entrusted with the duty of lawmaking, best understands the need of society and would not readily be assumed to have transgressed a constitutional limitation. The burden lies on the individual who asserts a constitutional transgression to establish it. Secondly, the courts tread warily in matters of social and economic policy, where they singularly lack expertise to make evaluations. Policy making is entrusted to the state. Doctrine of separation of power requires the court to allow deference to the legislature, whose duty is to frame and enact the law, and executive, and to the executive, whose duty it is to enforce the law. The court would not, in the exercise of judicial review, substitute its own opinion for the wisdom of the law enacting or law enforcing bodies. In the context of Article 19, the test of reasonableness was explained in the erudite words of Chief Justice Patanjali Shastri in V.J. Rao's case. It's a 7-judge judgment. It is important in this context to bear in mind that the test of reasonableness, wherever prescribed, should be applied to each individual statute impugned, and no abstract standard or general pattern of reasonableness can be laid down applicable to all cases. The nature of the right alleged to have been infringed, the underlying purpose of the restriction imposed, the extent and urgency of the evil sought to be remedied thereby, the disproportion of the imposition, the prevailing conditions at the time should all enter into the judicial verdict. In evaluating such elusive factors and forming their own conception of what is reasonable in all circumstances of a given case, it is inevitable that social philosophy and the scale of values of the judges participating should play an important part. And the limit of their interference with legislative judgment in such case can only be dictated by their sense of responsibility and self-restraint, and the sobering reflection that the Constitution is meant not only for people of their way of thinking, but for all, and that majority of the elected representatives of the people have in authorizing the imposition of restrictions considered them to be reasonable. The court in the exercise of the power of judicial review is unquestionably vested with the constitutional power to adjudicate upon validity of law. When the validity of a law is questioned on the ground that it violates a guarantee under 21, the scope of challenge is not confined only to whether procedure is fair, just, and reasonable. Substantive challenges to the validity of law encroaching upon the right to life or personal liberty has been considered and dealt with in varying contexts such as death penalty and mandatory death sentence. A person cannot be deprived of life or personal liberty except in accordance with procedure established by law. 14 is a guarantee against arbitrariness that infuses the entirety of Article 21. With this, Lord, finally, Lord, in 296, the danger of construing this as an exercise of substantive due process is that it results in the incorporation of a concept from American Constitution which was consciously not accepted when the Constitution was framed. Moreover, even in the country of its origin, substantive due process has led to vagaries of judicial interpretation, particularly having regard to the constitutional history surrounding deletion of that phrase in our Constitution. It would be inappropriate to equate the jurisdiction of a constitutional court in India to entertain a substantive challenge. So this puts paid to this should. But Mr. Singhvi referred to Shahra Banu and did not refer to Puttaswamy.
Loosely used.
Many questions. Up to 326 per annum. And in the case of INRI Section 6A, my lords, the Chief Justice, my lord, has dealt with manifest arbitrariness without bringing in the concept of due process, and it's virtually laid down whatever blood has been laid down in Puttaswamy independently.
Mr. Dwivedi, in fact, the first idea of manifest arbitrariness comes in the minority view of Vivian Bose.
Yes,
In the Saurashtra cases, Anwar Ali Sarkar is struck down
yes,
by saying it is illegal, unconstitutional. Then in the Saurashtra cases,
yes,
the majority, however, upholds the view, not agreed by Justice Bose. And Justice Bose says that if a law, my memory serves me right, if a law imposes punishment for persons who are red-haired, will that law survive?
correct.
That is manifest arbitrariness. But beautiful.
What is the manifest? What is fairness? So Now, we are always, Lord, impelled to cite judgments which are delivered by the bench itself, Lord, which is considering the matter. What's the paragraph behind here? Or is it I have not noted? Yes, at paragraph 218, kindly have that in the section 6A, I gave your lordships the सेपरेट दिया था ना? अच्छा ले आए आप? ठीक, ओके. Hmm?
Which paragraph, Mr.?
To that page 310, the discussion begins with paragraph 215, but I will place 218, Lord. This is very important for the first time, Lord, because manifest arbitrariness has to be explained. Lord. When do you say it is manifest? When it is not manifest? What is the extent of arbitrariness?
Constituents of manifest arbitrariness.
Constituents. The test of manifest arbitrariness itself was crystallized in the authoritative precedent set out in Shara Banu, where this court dealt with challenge to the practice of triple talaq, as recognized in the Muslim personal law. In that case, this court overruled its judgment in state of AP versus McDowell. 219. Thus, the test of manifest arbitrariness was set out. Manifest arbitrariness, therefore, must be something done by the legislature capriciously, irrationally, and or without adequate determining principle. Also, when something is done with is excessive and disproportionate, such legislation would be manifestly arbitrary. The test of manifest arbitrariness as propounded was eventually relied in a catena of decisions, including Joseph Schein and his prevailing facets. The term irrationality refers to lack of reason or logic, while highlighting the need for presence of clear reason or logic. This court in cellular operator determined that the legislation, statute, or provision being challenged must be supported by a rationale. Demonstrates that the application of intelligent care and observation in the enactment of such laws or provisions. To this end, it was held that we cannot forget that when viewed from the angle of manifest arbitrariness or reasonable restriction sounding in Article 14 and Article 19, respectively, the regulation must, in order to pass constitutional muster, be as a result of intelligent care and deliberation, that is the choice of a course which reason dictates. Then Joseph Schein is referred, Lord, the italicized portion, that it should be absolutely and manifestly arbitrary. Finally, come to 223. Still further, while the test of manifest arbitrariness requires the presence of logicality, such a reasoning does not have to be stated explicitly and can be discernible from the facts and circumstances. However, it should be noted that the converse may not hold. In other words, even if the reason or rationale behind the impugned provision is expressly stated, it does not automatically guarantee non-arbitrariness. Such reason also needs to align with constitutional morality and public interest and must bear a nexus with the object of the statute. The aspect of irrationality as found in the test for manifest arbitrariness thus does not solely imply the absence of reason, but also requires alignment with constitutional morality. Hence, the legitimacy of the reason or logic behind the impugned legislation should be viewed from the lens of constitutional ideals. This was also observed in the case of Joseph Schein, which was clarified that irrationality does not merely denote the absence of reason, but also requires that such reason be in harmony with constitutionalism. We may hasten to add that the legitimacy of the reason behind the legislation that has been impugned must be viewed from the lens of public interest also. This court in Hindustan Construction struck down the Section 87 of the Arbitration Act on the ground of manifest arbitrariness by observing that it was against public interest. This was also observed in Manish Kumar, that the golden thread running through the ground making up the doctrine of manifest arbitrariness is the absence of public interest. Extent of review under manifest arbitrariness. The standard for applying the test of manifest arbitrariness is reflected in the word manifest, which signifies that the arbitrariness should be palpable and visible on the face of it. Hence, while examining whether a provision is manifestly arbitrary, courts should practice judicial restraint and must not substitute their will against that of the lawmakers. Using this test, courts cannot question the wisdom of the policy, but can only test its legality in terms of the aforementioned grounds. I'm emphasizing this paragraph 225. That's the distinction where we divert from American judges. Such a judicial restraint becomes all the more necessary while testing arbitrariness behind a bright line test. In law, the bright line test is a clearly defined norm that does not leave a scope of interpretation. For instance, consider a legal requirement stipulating that individuals must be 18 years old to marry or to vote in our case. Such a rule leaves no room for interpretation. In this context, it would be argued that if maturity is the rationale behind marriageable age, the use of the bright line test introduces arbitrariness into legal standards, as a person aged 17.5 years old may in theory be more mature and suitable for marriage than someone aged so and so. Then if I may request the lordships to come to.
The next pair also.
Yes. Fallacy in this argument can be elucidated by the Socrates paradox, a logical quandary generated by vague terms which blurred boundaries of application. To give an oft-quoted example, define the term heap of wheat based on the number of wheat grains. If a collection of n number of grains is called a heap, removing one grain would not alter the assessment because the difference between a heap and non-heap cannot be of one single grain. By the same reasoning, removing two wheat grains would not change the classification. Extending this logic incrementally by deducting one wheat grain at a time, one could argue that even a heap with n minus n grains would not be a heap, leading to a fallacious conclusion. Applying this paradox to the above illustration, if an individual of 18 years is deemed mature enough for marriage, then logically someone who's 18 years minus 1 day should also be considered mature. Following the same reasoning, one could argue that a person who's 18 years minus 365 days, effectively 17 years old, would also meet the maturity criteria, and therefore a stipulation of 18 years as minimum age appears arbitrary, as it fails to account for the potential maturity of individuals who are younger. As already explained, there exists an inherent fallacy in this argument, and hence it ought to be rejected. In that sense, every bright line test to some extent is arbitrary. However, not every arbitrariness crosses permissible limits inherent in law. Indeed, the law sometimes prescribes these heuristic devices because the cost of arbitrariness is less than the grains received by prescribing a clear standard instead of keeping it vague. To put it differently, where arbitrariness is necessitated for a legislative distinction, the object of such a legislative act is also to prevent manifest arbitrariness. Then if I may come to 231, therefore, while testing the arbitrariness of bright line tests, the courts must be mindful of inherent limitations in such norms, and therefore a microscopic review should be avoided. Instead, as discussed above, the effort should be to determine if the bright line norm crosses the prescribed limit of manifest arbitrariness. If the bright line crosses the prescribed limit of arbitrariness and is irrational, capricious enough to strike down. If the norm is backed by policy reason, the court must refrain from excessively questioning the specific standard. I'm emphasizing this. Because there can always be two opinions. For example, 18 years of, well, it was 21, now it is 18. Someone can say, why not 17. Cutoff dates are prescribed in so many cases, even for submitting applications for employment, examinations. Somebody may come that what difference does it make? One more person is allowed. But your lordship strictly go by the. So some sort of vagueness or arbitrariness is not enough. It should be of an excessive kind. That is what is capricious or manifest arbitrariness.
Is it consistent?
खत्म हो गया ये।
Or three new?
दे दिया
Part three.
ऊपर दे दिया
Part three.
हाँ
Part three में तो नहीं मालूम but
So let me not put my SIR under the test. Does it meet this test as laid down in INRI section 6A? And keeping aside the due process despite the invitation of Mr. Singhvi. Some of the aspects I've already stressed, Lord, but if your lordship has with this part 3 at page 6, I have a table set out that where is my SIR departing from the rule and where how it Lord sticks to it.
This
Where
table?
it sticks. Yes, in the table.
table is in which volume? Which volume is this table?
I will not read the whole or ask your lordships to go through. Your lordship may just examine this Lord, and later on. But your lordship will find Lord, now rule 8. Just note rule 8 at page 7 bottom, where there is a departure. Rule 8 said the registration officer may, for the purpose of preparing the roll, send letters of request in form 4 to the occupants of the dwelling houses in the constituency or any part thereof, and every person receiving such letter shall furnish the information called for therein to the best of his ability. Now, what we have provided in the SIR is instead of sending a letter to request under form 4, which is discretionary, as indicated by the word may, we say that to electors, the BLO has been provided a pre-filled enumeration form to each elector through house-to-house visits requiring the signatures of the concerned elector on his EF for inclusion in the draft roll. So we are, instead of sending a letter of request, going to his house. It is noteworthy that, and we are going to the house along with the BLAs appointed by the political parties. It is noteworthy that instead of placing the burden on existing electors, the BLOs appointed by the ERO have shouldered the responsibility of going house to house of each elector so as to minimize hardship and ensure that their EF submitted. Additionally, existing electors, we have also provided e-facility to facilitate downloading. So apart from this additional mode, electronically you can download and do it wherever it is available. They can do that. That's additional. Then 3 is house to house. This is also in the SIR. Now 8A is followed, 8B is followed, 9 is followed. Now, this 9 is important because based on this, we have facilitated the obtaining of documents. If some elector who's poor, illiterate, if he is not able to get, if he comes to us, it shows that we have enabled the PLOs to go to the particular department and get a certificate for him. If his name is there in the registers, etc., we have obtained it. That's how 7.24 crores were enrolled at him. And in addition to BLOs, 4 lakh volunteers had been appointed for this. Now, publication of draft roll, this has been followed, and your lordships made it more effective and transparent by asking us to put it up. All political parties were given the draft roll. All over the country, we have been advertising, that even migrants who are there, they may take such assistance and adopt the digital mode. So at page 11, you also will find in the second column, the publication part. So we have been transparent, house to house, in presence of BLAs, publication in the website. We even sent out SMS, 4.5 crores, 5.7 crores whose mobile numbers are present with us. We sent messages to those personally that the SIR is on. Eleven again has been followed, and much more publicity than what is there in Rule 11. 12 has been followed. Now, what was changed is Form 6. We require an additional declaration with the 11+1 documents. The list of claims and objections which were filed also given to the political parties and published. When 65 lakhs, your lordship asked us to divide the categories and publish, that was also done, my lord. So whatever your lordships made it more transparent, your lordships made it more easy for the electors by asking the legal institutes not to help and assist in filing of objections and everything.
The interim directions, which some couple of interim directions
Yes.
for addition of documents, etc., which we passed in Bihar. Have you now yourself adopted them in the?
Yes, that is being adopted. Now, when this logical discrepancy arose in Bengal, one of your lordship asked that also to be published. We published that. As far as the earlier directions are concerned, regarding how many have died, how many have duplicates, and how many, all of them published in other states also. And there is so far no grievance on that score in the other states. So having gone through it, the only change is about the number of documents, etc. So to say that we are sailing far away from the rules, ignoring everything in the rules is not correct. We have changed wherever it was necessary. For example, ration cards, they wanted a lot. Earlier, 140% is the saturation of ration cards. So for good reasons, the authority had restricted it to 11 documents. And these documents, Lord, we are in 2025. When somebody who's a member of parliament comes forward and says people don't have, and ultimately, Lord, all the remaining 24% who were not linked in Bihar, they were able to file them. No voter has come to your lordships, Lord. This is very important, to which I will come, my Lord, finally. That this being the position with regard to, I humbly submit, my Lord, that our SIR cannot be castigated as being manifestly arbitrary, applying the test as elaborated by my Lord the Chief Justice in this section 6A. Oh, tell you to watch. Okay. I have said something in this volume towards the end about rights and duty being intertwined. And the political parties and others, except for pointing out this is not happening, that is not happening. Two persons were brought also, Lord. Ultimately, both are in the voter list. So, है तो वही सब है. Now, a question arises, my Lord, how far, my Lord, under Article 32, would your lordships be willing to go in scrutinizing the implementation at the level of the ERO, etc.? Because the attempt of the petitioners is really to convert it into an ERO, what has happened, what notice issued, what order passed, appeal not filed, still show to, a roving and fishing inquiry, which your lordships have always discouraged, unless there is something, the public interest will override, but it has to be, there's nobody coming forward. The voter is not coming that I have not been given notice. He is not filing an appeal, not filing a writ in High Court, not filing a writ in this court, not an IA in this court. At the instance of ADR, PUCL, and member of parliaments who are from Kerala, Tamil Nadu and all, who have joined together to find the petition. Would your lordships not go to that extent, my lord? I can understand if a voter had come, your lordship would have immediately asked us to rectify something in their interest, asked us to bring them back, examine and bring them back if they are right. Else, my lord, isn't it? In most cases, my lord, your lordships have refused to undertake a roving and fishing inquiry from every nook and corner of the exercise being conducted. Kindly have this case of 1985 Forest Constitution Bench judgment in Lakshmi Charan in the context of electoral rolls. (1985) Volume 4 SCC.
Volume 5.1.
Who have
5.4.
689.
Which one?
5.1. 5.1 part.
Kindly have paragraph 3. The voters had come themselves before the court. Then have paragraph 6. In fact, paragraph 5 also, they pointed out irregularities and some defects and difficulties, the polling booths being.
This was, yeah, this was not making reference to the.
It's just, you don't need to.
The further grievance, paragraph 6, made by the petitioners in the writ petition is that preparation of electoral rolls on the basis of polling stations was made arbitrarily and improperly. In that, the total number of voters in several constituencies after the house-to-house enumeration are differed in material particulars from the total number of voters in the draft electoral roll, which was published in the month of September 1981. It is alleged that draft electoral rolls were manipulated by including therein not only that draft electoral roll, not only Bangladesh nationals, but minors, dead persons, and refugees from Assam who were still living in refugee camps. According to the petitioners, these infirmities in the electoral roll were of such a basic inherent character that unless a further de novo revision of the electoral roll was conducted, it would be unfair to allow the elections to be held on the basis of the revised electoral roll. The revision work of the electoral roll, which was undertaken in West Bengal, could not possibly be finished within the time prescribed, since, so the petitioners say, the state was passing through a difficult period, particularly in the matter of law and order and because of natural calamities. The infirmities in the revised electoral rolls, which are pointed out by the petitioners, may be summed up as in the inclusion of teenagers and aliens therein, the exclusion of persons who are qualified to be enrolled as voters, the incorporation of fictitious entries and mistakes and distortions in names and surnames. One of the grievances of the petitioners is that these manipulations in the rolls became possible because of deliberate infiltration by the CPI and members of the government staff in the election machinery. Then para 11 sets out the reliefs which were sought.
In para 8, notices of complaints of violations, notices which were issued for the.
Para 6, 4, 5 lines last are the reasons, are the grounds on which the voter lists were questioned.
Yes.
Para 6.
Inclusion of teenagers, aliens, exclusion
Yes.
of those who were qualified, incorporation of fictitious entries, mistakes,
Yes.
and distortions in names and surnames.
And their argument in para 7 was that the scheme of election law and rules framed thereunder is so designed that unless all objections are decided by appellate authority and registration officers, and electoral rolls are correspondingly amended, especially when a de novo revision of the roll is directed to be made, it is impermissible to issue a notification under section 15(2) of the Act of 1951 for holding elections. So until appellate authority decides, don't hold.
So in a way, the principle laid down was that if you fail to invoke, apply, or undertake the exercise under 21(2), and you proceed to hold the election, that per se will not be invalidated only because the voter list
Was infirm in
Was-
some respect, somebody
was
was included,
suffering from
excluded.
impurities and were not revised.
Yes. Paragraph 16 may be seen.
8 May, they had conducted their own surveys to challenge that. That
This
was
is all right.
Yes, they have also conducted some surveys of the voters collective, etc., and relied upon it.
Paragraph 8 records that the petitioners made their own survey, Lord, and based on that they wanted to, just as in our case, Lord, they are trying to show various infirmities from various angles. Then paragraph 16, holding the elections to legislatures and holding them according to law are both matters of paramount importance. On the one hand is the individual statutory right of franchise, on the other is the constitutional obligation imposed by Article 168 that for every state there shall be a legislature. We find it somewhat odd that in the instant case, individuals whose rights are alleged to have violated have not come to the court at all. This is what your lordships also remarked, my lords. Not one of the 8 lakhs. Here, none, one of the 65 lakhs plus 3 lakhs who have been later on. Persons who have come to the court are members of political party who claim to represent them. While we are on this question, it must be emphasized that election laws do not recognize political parties except in Rule 11C of the Registration of Electoral Rules, the election symbol, Order 68, and Explanation 1 to Section 77(1). The right to be included in the electoral roll or to challenge the inclusion of any name in the roll is a right conferred upon an individual and not upon any political party. The petitioners are espousing the cause of unnamed and undisclosed persons through a writ petition, which does not even claim to possess a representative capacity. None of these petitions here before Your Lordship are claiming that. It's just hue and cry, there is flood, there is this, there is something. I mean, it's all sorts of issues projected. The upshot of the petition filed by them is that some 3 crores of voters were being deprived of an opportunity or exercise their franchise in order that an investigation should be made as to whether names of about some 5 lakhs and odd persons should be included or excluded from the electoral roll. The fundamental error from which the writ petition suffers is this: the fact that the revision of electoral rolls, either intensive or summary, is undertaken by the Election Commission does not have the effect of putting the electoral roll last published in cold storage. The revision of electoral roll is a continuous process which has to go on, elections or no elections. For example, the revision of electoral roll has to be undertaken under Section 21, whether or not an election is impending. Section 21 provides that electoral roll for each constituency shall be prepared in the prescribed manner by reference to the qualifying date and shall come into force immediately upon its final application. Subsection 2 provides for revision of the roll prepared and so and so. The proviso, which is important, says that if electoral roll is not revised as aforesaid, the validity or continued operation of the said roll shall not be affected. Now, somebody could have said in Inderjit Barua's case that you are going by 79 list and election is being held in 83, 4 years gone, so many voters not put on the roll and they have been deprived. The court said no. In view of the proviso, the list, if not revised, the prevailing list will be followed. Then 18, Section 21(3) of the Act confers upon the Election Commission the power to direct a special revision of the electoral roll. The proviso to that section also says that until the completion of special revision, so directed electoral roll for time being in force shall continue to be in force. That proves the point that election laws abhor a vacuum insofar as electoral rolls are concerned. There is never a moment in the life of political community when some electoral roll or the other is not in force. Section 23(3) of the Act of 1950 also points out in the same direction. Under that provision, no amendment, transposition or deletion of an entry can be made under Section 22, and no direction for inclusion of the name in electoral roll of a constituency can be given after the last date of making nomination for an election in a particular constituency. Election has to be held on the basis of the roll, which is in force on the last date for nomination. Please come to para 20 in the middle. Just 2-3 paragraphs more. Thus, the fact that an appeal is pending, that's middle of the paragraph of para 20. After 4 lines, Rule 22 imposes upon the registration officer the obligation to publish the electoral roll, which together with the list of amendment becomes the roll of the constituency. Thus, the fact that an appeal is pending before Rule 23 against the decision of registration officer under Rule 20, 21, 21A does not constitute an impediment to the publication of roll and to the roll upon such publication coming into force. Rule 20 provides for inquiry into claims and objection. 21 provides for inclusion of names which are left out. 21A provides for deletion. Notwithstanding the fact that the roll contains these errors and they have remained to be corrected, or that the appeals in respect thereof are still pending, the registration officer is under an obligation to publish the roll. The election in this next paragraph, last sentence, election has to be held on the basis of roll which is in force. And they say election laws 22 is important. After 5 lines, election laws are self-contained code. One must look to them for identifying the rights and obligations of parties, whether they are private citizens or public officials. Therefore, in the absence of provision to that effect, it would not be correct to equate the directions given by Election Commission to the chief electoral officers. The Election Commission is, of course, entitled to act ex debito justicia in the sense that it can take steps or direct that steps be taken over and above those which it is under obligation to take under the law. Please mark this, para 22. It is therefore entitled to issue directions to the chief electoral officers. Such directions are binding upon the letter, but their violation cannot create rights and obligations unknown to election law. So therefore, my lord, unless the voters, my lord, are there, the grievance specific to voters ought not to be looked into. But we have gone still, my lord, to the extent possible, my lord, to satisfy your lordship's judicial conscience that our order and the exercise of powers under the order are done in a fair, just and reasonable manner. Some errors here and there, my lord, whoever prepares the electoral roll, nobody can vouch, my lord, that it will be perfect at the end of the day. Why, my lord? We act, my lord, on the basis of employees of the state. See, look at the forces which are operating. And whereas so many contradictions, my lord, which emerge in this. So it's bound to be, my lord, because people are from there. If they are wanting to assist A, B, or C, or D, or something here or there is bound to happen. Whatsoever intensive an exercise is. The question is, are we making a bona fide effort in a reasonable, just, and fair manner? And we are able to demonstrate that there is nothing manifestly arbitrary in the exercise of powers. There is some. If your lordship wants, I can explain what Mr. Yadav's chart and all those things. Just 10 minutes, I will.
That will be able to examine such factual issues.
Or if your lordship gives me 5 minutes, I can just show.
Yes, you can. You have, you are entitled
sorry
to
for
at least
detaining
10 minutes more.
No, Aadhaar is already directed to be deleted. I'm not dealing with Aadhaar, etc. Your lordships have already directed it for identity.
You have passed a detailed order
Yes, sir.
and you have, that,
I
as
have an
you said,
IM
you have followed
I
for
will-
the future also.
I will make my submissions on that, madam.
Then we'll respond thereafter. Then there was something about searchable format, my lords. I submit that Kamal Nath's case, Lord, completely covers that. It has, what has said, which involves privacy, it has to be left to the Election Commission. In any case, Mr. Prashant Bhushan represents forces, Lord, who are able to provide those necessary funds and equipment to do the searchable, which he has tried to do. Lord. So as far as voters are concerned, they have nothing to do with this searchable format. And this election law is not supposed to aid the research of the ADR. One, if your lordship has page 37 of this last note, just 2-3 paragraph.
Volume 4,
Yes,
part 4.
paragraph. We have tried to demonstrate the various false and fictitious statistics placed. And how loosely the affidavits, paragraph 67. Additional affidavit, Lord, kindly have the last 7 lines at page 37. Just above paragraph.
Yes.
Additional affidavit 8-10-25 in para 12 asserts analysis has been developed with the help of some IT experts and data scientists. Now, Lord, how do we accept the veracity and authenticity of the statistics which he was trying to project? And the effort was to show a mismatch between the estimated adult population, and he was saying, where have the 81 lakhs gone? Population shown by some government department says something higher figure. In order to, then 68, in order to show that SIR has swelled missing voters, Shri Yadav tried to refer to a graph and a chart which deals with the period 2011 and 2025. These documents themselves indicate that up till 2022, the number of voters were more than the projected total population. And that justifies the exercise of SI. In fact, my Lord Justice Bakshi had remarked, Lord, when he was placing it, that this justifies the SIR. Now kindly look at, we have been able to get the report of the technical group. And the technical group, which was not annexed before your lordships. The bold portions, the projection population is a scientific attempt to peep into the future population scenario conditioned by certain assumptions. Using past data, assumptions used and their holding true is a critical condition in this exercise. Predicting the future course of human fertility and mortality is not easy, as medical and health interventions, production of food, etc., and a host of factors influence population dynamics, making it difficult to predict population uncertainty. Therefore, caution must be exercised while using the projected numbers in the context of various assumptions prevailing. Apart from dynamic growth arising out of physical problems, it may also be added that despite the best efforts in the census for complete and correct enumeration, slight omission or duplication of population during enumeration cannot be ruled out. In estimation of fertility and mortality from sample registration system, there may be some under or overestimation. Now, based on that, your lordships were told not that look at the infirmity in this. 81 lakhs have gone. Now look at this next paragraph. Another serious flaw is that the ratio projected deals with a short period to represent a distorted analysis. This becomes evident on a consideration of the graph 2, which deals with gender ratio. The correct graph regarding gender ratio from the year 1962 to 25 is being reproduced below. If your lordship comes to this graph, kindly mark not a line from 2010 to 2025. 2010 to 2025. Just below that. This is the limited graph which Mr. Yadav presented. And he tried to show that, look, it's going up and went up to 907, but came down to 892 in Bihar. But if you look at the whole blood from 1962, kindly see the up and down and up and down. So it's never been a static graph. Now what follows from this, just because from 907 it comes to 892, he says that that reflects that the design is faulty. So what was the design earlier, Lord? Statistics, Lord, are very dangerous. It depends upon what data set is projected before the court. If it is a limited data set, gives a different picture. If it's a wider data set, Lord, it gives the true picture. So it is bound to fluctuate for various reasons. Even the voters sometimes, Lord, they may not be in the state, they may not be wanting to get into it. The voters, they don't, as we all know, 30% did not vote. I submit not that these kind of and lastly, Lord, I deliberately did not take any preliminary objections in the beginning to the effect that voters are not there who are there before. In addition to this, how was the writ petition filed? Within 6 days of our SIR order, without it being implemented, the writs were flooded in this court. And they were all based on self-written articles. So Mr. Yadav first writes an article in a newspaper, and then Mr. Bhushan presents a writ petition in this court annexing that article. Every writ petition is based on such articles written 6 or 7 people, common, same newspaper articles. Notwithstanding the fact that the lordships have criticized this, I have given at page 42 and 43 the judgment in ADR case regarding EVM, repeatedly filing EVMs. So it has become a fashion, Lord, that they attack the election commission in order to win the election. Kindly see the bold portions at page 43. Your lordships have criticized. I have heard senior counsel for the three petitioners suspect without, however, attributing any malice to the election commission in which West's direction control of elections under 324, efficacy of the right of franchise. Bold portion, I have also heard the counsel for petitioner association in the lead matter relying on certain reports to persuade the court to hold that casting of votes through EVM is not a foolproof and that voting through electronic means has been discontinued by European nation. So in short, Lord, we must follow what Europe does. If they go for EVM, we should go for EVM. If they paper, we go for paper. He also heard to suggest that when called upon the court regarding the nature of relief, the petitioning association seeks that the electoral process in India should return to paper ballot. I place on record that although such a suggestion was subsequently withdrawn, the council in course of proceedings. In fact, it was withdrawn by learned friend Maninder Singh Lord. He was representing commission on his protest. The withdrawal was more of an attempt to erase the impression we, the judges forming the bench, were urged to form by the senior counsel for the ECI, while arguing that the petitioning association utter lack of bona fides in invoking this court's writ jurisdiction under 32 of the is completely exposed thereby. I have no hesitation to accept the submission of senior counsel for ECI that reverting to the paper ballot paper of bygone era as suggested reveals the real intention of petitioning association to discredit the system of voting through EVMs and so on. It is of immediate relevance to note that in recent years, trend has been fast developing of certain vested interest groups endeavoring to undermine the achievements and accomplishments of the nation earned through hard work and dedication of its sincere workforce. There seems to be a concerted effort to discredit, diminish, and weaken the progress of this great nation on every possible frontier. Any such effort, or rather attempt, has to be nipped in the bud. No constitutional court, far less this court, would allow such attempt to succeed as long as it has a say in the matter. And I have serious doubt as regards the bona fides of the petitioning association. Same ADR. And once again, their friend in one petition writes an article, other person files, annexes that article and files the petition that these are the errors. The other lordship is similar. These are the main aspects which I wanted to highlight. And I submit, therefore, all the petitions should be dismissed, my lords. My friend says with special cause.
Thank you, Mr. Dwivedi.
I am grateful.
I have a substantive petition, Lordship say that I'll be after Mr. Dwivedi, so Lordship will give me Lord next date whenever it is there. I'll take hour and a half, sir. But I will not duplicate, my lord. I'm taking notes of, my lord, whatever Mr. Dwivedi has asked. I will not cover the area, my lord, which is covered by Mr. Dwivedi. It will be
Well, it will grant you 15 minutes on Tuesday.
15 minutes may not be sufficient, my lord. 15 minutes may not be sufficient, my lord, because Lordship.
You will not repeat
No,
anything.
my lord, I will not repeat. Lordship will take it from me. I will not repeat anything, my lord.
So 15 minutes is sufficient.
My lord, I said, my lord, my thing, but they were saying we must argue for 2 hours. I said, Lordship will give me an hour or so, my lord. I have my written submissions and with my, my lord.
All right, maximum half an hour. Going by watch, 30 minutes we will grant you on Wednesday, because Tuesday is likely to be miscellaneous day.
Please, your lordship.
Tuesday it might
On
be
Wednesday.
miscellaneous day. So we'll take up the on Tuesday, and thereafter,
Wednesday.
how much time you will approximate?
I think we should follow your SOP, my lords, very honestly. I
Huh?
mean, you have an SOP for this purpose. I think we should give you times as per
So
that.
this matter had already started, that's why we did not insist, but you can just give an estimated time.
About, I'll take about 15 minutes, my lords.
15 minutes.
Minutes.
Yes,
Just please give us, you can give even on Tuesday also.
yes,
Huh?
we'll do
We'll do
that.
that on
We'll do
Tuesday.
that.
Tuesday also, just give us the time. So
My lords, there are one or two more councils on this side before Mr. Ansaria begins.
Oh.
There are one or two more councils on this side before Mr. Ansaria
Mr.
begins.
Maninder Singh is here, but Mr. Maninder Singh has very, though we didn't had the advantage of his wonderful voice, but then he has been assisting arguing through Mr. Dwivedi.
So if I can have 10 minutes on Wednesday.
I think Lordship may grant Mr. Dwivedi.
Unanimity, whatever we had give a little inputs here, my lord, he was very kind and he has added everything in the note, everything is covered.
No,
We have a note, my lord, if
if
need.
if you want to add something, then we will definitely grant you also time.
Only 10 minutes, my lord, if you want.
We will grant,
My lord, virtually it's going to be a repetition.
all right, 15 minutes to you,
Yes.
15 minutes to you, 10 minutes to you,
Grateful.
right? 25
And thereafter, my lord,
and
can order.
25 plus 25 to
30 minutes, Lordship said, my lord.
10.
I'll finish in 30 minutes.
Grateful, Lord.
Please, Lord, I'm grateful. Very grateful.
Understood.